I didn't realize that Mr. Pepperman was a chemist.
Oh, 26?
Yes, Your Honor.
The motion.
No, 26.
Your Honor, this is plaintiff's motion in limine number 26 to preclude defendants from arguing that they can delegate their obligations to government agencies or that prior permitting, past inspections, or compliance with other health or manufacturing regulations is a defense. During discovery, it became apparent to the plaintiffs at least that defendants were going to attempt to argue or at least infer that the fact that real water was previously inspected or permitted by the Southern Nevada Health District or had complied with other health or manufacturing regulations that weren't relevant somehow warranted that everything at the facility or that the product was hunky-dory. Sure enough, the opposition to this motion demonstrates that that's exactly what the defendants hope to do. And by this motion, we ask the court to preclude these arguments. If we could go to page 3 of the motion, please, Chris. And if we can just start on the first line of NRS 41.033. Lines 4 to 7 at the top. So again, Your Honor, as they demonstrate in the opposition, defendants hope to argue that the fact that they were previously inspected and permitted by Southern Nevada Health District is somehow a warranty or assurance that there weren't any hazards or deficiencies at the real water facility or with the real water product. So I'm starting with NRS 41.033 because
I mean, you don't have to go into great detail. This reminds me of the argument that used to be made in Chapter 40 cases. Your Honor, they came out from the building department and it was inspected. There can be no Chapter 40 construction. I think I heard that a few times. But go ahead.
That's exactly the point, Your Honor. That's the, you get to the heart of it much quicker than I do. That's it. That's the issue on the inspections and the permitting. They also raised in the opposition this idea that they were registered by the FDA. But that FDA registration, it's nothing but a form that every manufacturing facility is required to submit in case there's an outbreak so that their address, their contact information is all on hand for the ensuing investigation. So the fact that Real Water has submitted this form or complied with the requirement to submit this form, that's not relevant evidence as to any factor in this case. The other thing that I'll mention on this is it's factually wrong. I think it misconstrues the facts because the testimony from the Southern Nevada Health District representatives are that, yeah, they were out there, they had previously permitted them. They described what that entailed, which was simply just making sure they had the proper equipment that was capable of being cleaned, was capable and appropriate for its use. That was connected correctly. They weren't making any determinations other than what minor things at that time that existed. And in addition to that, there were numerous problems with Real Water in the Southern Nevada Health District. There were multiple cease and desist for practices that were going on by the Southern Nevada Health District. there were numerous records of violations, OSHA inspections, OSHA violations. So to suggest that these facts that Southern Nevada Health District was out there, or that they had been permitted at certain times, those facts don't tell the whole story. It's not a viable defense under Nevada law to begin with. It's irrelevant, it's prejudicial, it's confusing, it's misleading. So for all those reasons, we'd ask that this motion be granted and those arguments and similar arguments like it be precluded.
Thank you, sir.
Your Honor, Joel Odou on behalf of Will Water. It is a little bit like a construction defect case, except in a construction defect case, typically you don't have the plaintiffs arguing the homes were never inspected, because that does make the inspection relevant. Here, that's what we have, Your Honor. We have the plaintiffs going on and on. In fact, the other day, we were arguing about OSHA violations. And the plaintiffs wanted to put on evidence of OSHA violations, which are completely irrelevant to this case. But it goes to the fact that they keep raising these inspection issues and saying that they want to put them before the jury. Well, then they've got to have it both ways. If there are inspections where real water passed and was permitted, that is certainly not anything on negligence or strict liability, but it is on negligence per se, and it is a response to that. So if the plaintiffs have opened the door, we believe real water should be allowed to respond.
And Your Honor, UNFW opposed also, if I can, get in front of the court. Judge, I'll remind the court that the plaintiffs largely hold the outcome of this motion in their own hands. The second amended complaint includes not just the strict liability count, but also the negligence count and the negligence per se count that Mr. Odou just alluded to. I want to ask Mr. Stevens to put up the plaintiff's motion in limine number 13. This is a close cousin to that. Plaintiff's motion in limine number 13, Your Honor, was captioned, well, I forget, but something to the effect of, John, thank you. Plaintiff's motion in limine number 13, Your Honor, was captioned, motion in limine to preclude UNFW from arguing or inferring that violations of the law or regulations are relevant to the compensatory or punitive liability of UNFW. Page 4, please, John. In that motion, Your Honor, the plaintiffs make an admission that's, I think, fatal to this motion in limine number 26. On page 4, they say, just as the court has repeatedly, correctly, in a strict liability case, the conduct of the party doesn't matter. They say such evidence is only relevant in a negligence action where due care or the reckless disregard of due care is in contention. When the plaintiffs include a negligence count or a negligence per se count, they broaden the scope of admissible evidence to include the violation of or compliance with applicable regulations and law. And I think Mr. Odou made that point well. I think that's one of the bases for the court's admission of OSHA violations and FDA EIRs and 483s and other issues of the sort. If the FDA's EIR of an unpermitted facility in 2020 is admissible, then the fact that a different facility in 2018 and 2019 that was making water for Mr. Belsky and Mr. Haley, the fact that it was permitted and inspected and audited ought to also be relevant. And that's indeed exactly what the law is. That's what Robinson versus GGC says. It says evidence of compliance with regulatory standards is relevant to the burden on the manufacturer to design a safe product. That's a Nevada Supreme Court case, 107, Nevada 135. Price versus Senate is another Nevada Supreme Court case that says the same thing. Proof of, and this is a reminiscent of the Goose Gander rule, the proof of a deviation from an administrative regulation is only evidence of negligence, not negligence per se. Neither is proof of compliance with such a regulation proof of due care as a matter of law, but rather it is evidence of such care. It's always admissible. It's never dispositive. And so we can certainly tell the jury that we, UNFW, contractually required Mr. Odou's client to comply with the law, and they did when they made Belsky and Haley's retail bottled water. Now, whether the jury accepts that as evidence of due care or rejects it as a baseline minimum standard is up to the jury. But the plaintiff's motion seeks to prevent us from even admitting it, and that's not Nevada law. That's not any law that I'm aware of. We cite, in addition to Robinson and Price, we cite the Breyer versus American Honda case, where Justice Breyer from the Supreme Court noted that, quote, even though good faith compliance with the minimum requirements of NHTSA, National Highway Transportation Safety Administration, regulations would not provide the defendant a complete defense on the merits. I assume that such compliance would be admissible evidence tending to negate charges of negligent and defective design. So again, Your Honor, if the plaintiffs choose to keep negligence and negligence per se in the case and punitive damages on standard of care issues, they automatically render the compliance with applicable regulations and statutes admissible. They have options beyond that. They have not elected to pursue those options. And the last thing I'll say, Your Honor, you perceptively said, well, this reminds me of a Chapter 40 case. That's the statute that Mr. Pepperman cited, NRS 41033. That's, of course, in the chapter on liability and actions against the state, its agencies, and political subdivisions. If I'm suing the state for a bad inspection, their inspection doesn't warrant a safe premises, but that's not at all what's going on here. And again, the plaintiff's election to include the negligence count makes it relevant, Your Honor. So for that reason, we ask that the court deny the motion.
Thank you, sir.
Your Honor,
Yes, Mr. Kavanaugh.
Stillwater of Tennessee joined in AffinityLifestyles.com and Real Water Inc.'s opposition to motion eliminating 26.
Addressing Mr. Odou's argument first, where he tries to distinguish this from the many cases in different contexts where this same argument is typically tried, that in this case it's different because there was no argument in the Chapter 40 cases, construction defect cases, there was no argument that the place was never inspected. That's true here. We've never suggested that Southern Nevada Health District wasn't ever at Real Water's facility, or that they weren't ever there inspecting the premises, or that they didn't issue permits at different times, or that they didn't suspend those permits at different times, or issue violation notices or cease and desist letters against that permit. We're not, all of that happened. All we're saying is the fact that Southern Nevada Health District was out there and may have inspected or may have granted permits at different times is irrelevant and does not warrant or ensure the absence of any hazard or deficiency at the facility. And that's exactly what NRS 41.033 says. That's all we're asking, is to say they clearly want to come in here and they want to make an argument that, oh, Real Water was great in 2018 and 2019, no problems, because the Southern Nevada Health District was out there and they signed off on it. They inspected it, they were there, they warranted that this was fine. That's what they want to tell the jury, Judge. And that's what NRS 41.033 expressly and specifically precludes. We're just asking that they be precluded from making the argument that's expressly rejected in NRS 41.033. The argument that 41.033 only applies in a Chapter 40 case, or it only applies when the state is being sued, is unsupported. I mean, where's the case or the law that says that? NRS 41 is a different provision than NRS Chapter 40. And as Your Honor seems to recall, that this same issue has been brought up in those cases. It's been brought up in these cases too.
Well, I mean, it's brought up a lot, like in medical malpractice involving hospitals. Issues come up regarding whether or not the hospital is accredited by the Joint Commission on Hospital Accreditation, and whether that comes in, whether the whatever the facility might be as far as, or the inspector might be, but it comes up a lot in various different areas. And the thing about it is typically it's not a defense. And here's my point: the thrust and focus is on issues regarding the conduct at that time. And I understand there's a negligence case in here, and I just want to go back to this. Is it 41033?
Yes, sir.
Because I have a copy of the Robinson case. I just want to make sure I get the appropriate.
Subsection 2.
Okay. Go ahead, sir.
Again, NRS 41.033 subsection 2, it's plain. Its plain language provides that, you know, the fact that a facility has been inspected by a government agency does not warrant or ensure the absence of any hazard, deficiency, or other matter. So at bottom, the plain language controls, and the defendant should be precluded from arguing the opposite of what the statute precludes.
So this is under remedies and other actions in the concerning persons.
Yes, Your Honor, in whole, the statute says that an inspection conducted with regard, a government inspection conducted with regard to a private building, structure, facility, or improvement constitutes a public duty and does not warrant or ensure the absence of any hazard, deficiency, or other matter. The health district is out there, as we make clear in the reply, they're out there to perform basic duties such as making sure that there's proper equipment there, making sure that the equipment is hooked up properly. I mean, these are the minimal standards that they're looking for to decide or to grant an application for a permit. They're not looking at their manufacturing processes, they're not testing the product, they're not doing anything other than basic government functions to ensure the proper permitting. The obligations to manufacture, to apply quality controls, quality procedures, make a safe product, that's on the facility. And to argue that they're somehow delegating that duty because the Southern Nevada Health District was on the premises and didn't shut them down at a certain time, that is an argument that they're delegating that duty, and that it is the health district is essentially warranting or ensuring the absence of any hazards or deficiencies. And that is exactly what NRS 41.0332 precludes.
So how does Robinson have any impact on this case? I'm just curious. I know what the statute says.
So with respect to Robinson, Your Honor, first, Robinson, that involved the failure of the defendant's product to comply with a standard. There
were ANSI standards, and I know what ANSI standards are. And essentially, the ANSI standards came in as evidence of product safety. which is not surprising because, I mean, I remember one of the first things I discovered as a young lawyer was the fact that, and this kind of surprised me, that there are standards for almost everything. I mean, ASTM standards, ANSI standards, and all these things. And I remember one time as a young lawyer, Neil Gallagher told me not to take a case involving a slip and fall in a bathtub at the Dunes Hotel. But the lady suffered a hip fracture, so I tried to help her out. And lo and behold, I found out, because I talked to the expert, and I said, are there standards for this? And he said, yes, there are, you know, regarding bathtub safety. And you break it down into quadrants. And it was such a unique case, I still remember to this day, the, I guess the tool used to test coefficient of friction on a bathtub surface, you know? It was a bone grabber. I remember that. This was going back almost 30, 40 years. And ANSI standard says you fail one of the quadrants, you fail them all. And at the end of the day, the old Dunes paid money on that case.
Was the standard admissible, Your Honor?
Oh, absolutely.
Absolutely.
Yeah, it was. I mean, that was the standard, right?
Well,
That's one of the first things I learned, but see, I'm trying to figure out what's going on here, right? Because this case stands for the proposition that an ANSI standard would come in, right? That's much different than inspections, right? And more importantly, the ANSI standard dealt specifically with product manufacturing, right? And there wasn't a standard in place per se, but ANSI's there. And I can't remember as a young lawyer whether it was ASTM or ANSI, but I know it was a standard, and that's the standard I relied upon. And that's the standard upon which the tests that were performed regarding bathtub safety.
Yes, Your Honor.
See, that's a different issue.
It is, exactly. It's exactly a different
I get
issue.
that.
And so in Robinson, if you recall, that was the box machine where the box boy got his hand caught in the machine, and there was an allegation that there was a safety device that should have been used on the machine, and that the safety device was defective because it didn't have the safety device. And so one of the arguments was, well, look, now after the accident, there's an ANSI standard that requires the safety device to be on there. And so the issue was, well, that was after the fact. Is the evidence of the ANSI standard?
That's a different issue.
Completely different than here.
From whether or not you passed inspection by the county.
Yes, and it's also different in another respect too that I think is important. Because it's one thing if there's a standard that applies that you're complying with, and whether or not you complied it, that is a different question and has potentially different relevance under those facts. It's completely different when there's no standard that applies, and the argument is, well, we didn't violate this standard that doesn't apply to us. And so that is a different scenario as well. And that's essentially what they're trying to, or I guess really what the main distinction here is that it's an inspection, that it's not some standard that they're being judged against, that whether it applies or doesn't apply. And they're trying to make an argument. It's basically, oh, jury, you should find that there's nothing wrong with real water at this time because Southern Nevada Health District was on the premises at one point and they didn't shut us down. That's the argument in essence of what they want to make to the jury. And that's expressly prohibited by NRS 41.033. And it's plainly prejudicial, misleading, and confusing, and should be excluded on those grounds.
All right, this is what I'm gonna do. And I thought about it, and I did take a look at Williams, it's totally different. It's products liability case, not a negligence case. But more importantly, the ANSI standards that were used in the Robinson case went to product design and manufacturing. That's a different issue, a totally different issue. And there are standards for almost everything that surprised me. You can deal with coefficient of friction of water surfaces, subsurfaces, it deals with many different things, it just does. And whether you've passed an inspection or not with the local agency is not relevant. It's not, it really isn't. It's like in a Med Mal case against a hospital, and the Joint Commission on Hospital Accreditation, that's not coming in, right? And it's kind of like the same thing, it really and truly is. The issue is whether the standard of care at the time was deviated from, or there's an effective product, or whatever, but anyway, that's my decision. But I'm glad we vetted it, I understand what was going on. Move on to the next one.
The next one involves, one of the meter defense expert,
Where are we at now? Next
involves
one.
the meter defense expert, Dr. Babcock, and I think this will probably take about 45 minutes.
I think we need about, we think we need.
Yeah,
about-
I think maybe we ought to do our afternoon break now, because as I understand, we're breaking at 4 o'clock today.
Right.
We are.
Yeah.
All right.
All right. Part 16 will now recommence. Please be seated.
We're on the record, I guess we can continue. Okay.
Thank you, Your Honor. This is plaintiff's motion eliminate number 28 to exclude all evidence, testimony, and/or expert opinions related to testing conducted by defense expert Jason Babcock, because the testing was not substantially similar to the conditions that existed at Water. So Dr. Babcock is a chemist retained by Hanna Instruments in this case. But Dr. Babcock is not an ORP meter expert. He has no specialized knowledge, training, or experience on ORP meters specifically. He testified that he may have used one a dozen or so times in school or as part of random projects, but he never used one to measure negative ORP, which is the issue in this case, and then he never used the Milwaukee 500 meter or conducted any studies, publications, or research regarding ORP meters. Dr. Babcock has formulated several opinions in this case that are based exclusively on testing that he conducted. And so when we look at the admissibility of expert opinion testimony and evidence of expert testing based on the results of a technique, experiment, or calculation, then Nevada law requires that the testing be conducted under substantially similar conditions as those that existed in the underlying incident. And that's the Hallmark case, and it, as Hallmark for that proposition, quotes the Wren v. State case. This substantial similarity requirement is a foundational requirement, and the burden of showing substantial similarity is on the proponent of the expert evidence. If testing is not substantially similar, evidence of the testing or the opinions based on the testing are inadmissible for very common sense reasons. First, it will not assist the jury. If an expert conducts testing under dissimilar circumstances, then any suggestion that the testing or conclusions or opinions derived from the testing, any suggestion that they apply to the facts at hand are entirely speculative. You can't say that the testing applies unless you do the testing. And if you do the testing under different conditions and then try to apply it to the conditions at hand, it's not based on anything but speculation and conjecture that the testing or conclusions on the testing will apply. Second, the second reason why substantial similarity is required is because when you have testing under different conditions and you admit it as somehow relevant or probative to the incident at hand, there's a substantial risk of confusion, misleading the
That goes to
jury.
reliability too.
Goes to reliability, yeah, that's it, exactly. Again, thank you for getting to the heart of my argument.
I mean, go ahead, but I mean, that's apparent, I understand what he has to do under the assistance requirement. I get it.
So, Chris, if you could pull up the motion. At page 6, please. And if we can just blow up the testing procedure, lines 3 through 19. First, Your Honor, I just want to just generally provide the overview of the testing that Dr. Babcock conducted here. So essentially what he did.
This is from page 6, right?
This is page 6, yes. So Dr. Babcock, first thing he did was he made a test solution of negative ORP, a negative ORP test solution. Then he took the 15 Milwaukee 500 test meters that he used, and he started taking measurements of the test solution to see how long it took the meters to stabilize, for his words are a couple seconds, and then he jotted down the time that it took for the meter to reach the negative ORP where it stabilized, and then he wrote down the time, and then he would repeat that test under different conditions. After, at first he did it all 15 meters right out of the box, then he put them in the storage cap with white vinegar and stored them for 5 minutes, and then he tested all 15 again, then he put it back in the storage cap with white vinegar, and then he waited 24 hours and tested them again, 48 hours, tested them again, he repeated it at 5 minutes, 24 hours, 48 hours, 72 hours, and 96 hours, I believe. He then recorded all the data from the time and drew conclusions regarding the stabilization time, how that might affect the conditioning of the probe in vinegar for different intervals. So that's the testing that he did. In the motion, we explain why this testing is really not relevant to begin with, but I don't want to bog the court down with those issues, because I think that the main issue here is, the main question presented is substantial similarity. Did Dr. Babcock conduct his testing under conditions that were substantially similar to those that existed at Real Water at the time that Real Water was making water? If the answer is no, then the testing is inadmissible and must be excluded. I don't think there's any dispute as to that. So, in the motion, we also lay out numerous dissimilarities between the testing conditions that Dr. Babcock used and the conditions that existed at Real Water, but I'm just going to focus on the two big ones. So the first problem, well, I think that either one of these two big differences renders Dr. Babcock's testing inadmissible by themselves, either one. But together they make this what we believe is an easy question, that this testing was just not similar to the conditions that existed at Real Water, and Dr. Babcock's attempts to apply his testing or opinions from it to the facts at issue is just too speculative and does not meet the admissibility and reliability standards under Hallmark. So the first problem with Dr. Babcock's testing is that he tested different meters than the meters that were used at Real Water. And if you could go to page 8 of the motion. motion, we put the pictures of the 15 test meters on the left and the picture of the meter that was actually used at Real Water on the right. And so obviously the physical differences between these meters are apparent. The Real Water meters were different casing, different coloring, different probe coloring, physical apparent differences in the meters. And it bears emphasis that Dr. Babcock did not perform his testing on the meters that were actually used at Real Water or the meters that looked similar to the ones at Real Water. He performed his testing on the newer style Milwaukee 500 meters, which had the black casing and the green colored probes and the physical differences. So Milwaukee at some point changed its manufacturing and went from the prior meter used at Real Water to a newer model meter, and the newer model meters are what Dr. Babcock did his testing on. Now,
Didn't Real Water have quite a few meters available?
Yes, Your Honor, they did, and those meters were collected. For example, this meter that's in the picture on page 8 of the motion, meter was found at the facility. That picture was taken when we first inspected the facility back in, I believe, April 2021, I think. And any of the meters that we saw, there were several other meters. We preserved those meters. We stored them. We requested permission from the courts at that time. I believe the first case of the order was by Judge Gonzalez. In one of the other cases where we were granted permission, we got court approval to set up a joint storage facility. We worked with the other defendants. We went and got as many of the meters as we could from the facility, and we stored them in a joint storage location under the terms of a court preservation order. So these meters were available. Dr. Babcock did not do his testing on those meters. And in fact, Dr. Babcock never even looked at the meters that were used at the time of Real Water. And that is a very important issue, which I'll get to in a moment. So we know that the physical appearance is obvious. They're different meters. They look different. Okay, well, what about the fact, how does that impact the testing? Well, it's very interesting, Your Honor. It turns out that there are differences that were not just visual difference, it's not just coloring, but differences that affected the test results. And so what Dr. Babcock did was, as I mentioned, he tested all 15 meters and at the different intervals, after 5 minutes, 24 hours, 48, and recorded all the results. And what happened in his results was he had 15 data points for each meter. And 13 of them were, they weren't exactly the same, but they were, within a range of each other. They were somewhat consistent, I would say. But 2 of the meters were not consistent at all. They were what Dr. Babcock called statistical outliers. And they were so different that Dr. Babcock excluded the results from these 2 meters from his testing results. He determined they were different.
There were 15 meters, right, tested?
15 meters tested.
How can you determine whether something's a statistical outlier with only 15 meters tested?
Well, that's a good question, Your Honor. I did ask Dr. Babcock that, and he provided a technical explanation that they were so different from the other 13 that he determined they were statistically considered outliers and excluded them. But his explanation for excluding them was just based on the statistical differences between the results. But it is something that they looked at and they talked about. And if we could, first go to page 10 of the motion.
Yeah.
And so what Dr. Babcock did was he said, all right, I have 15 test meters, and I'm getting results from 2 meters that are completely different than results from the other 13 meters. So he started looking for an explanation as to why. So the first thing he does he does this very detailed comparison of the probes of one of the meters, one of the 13 meters, and one of the statistical outlier meters. And that's figure 8, and it's on the motion. That's directly from his report. And he says, well, he starts noticing, small differences between the 2 probes on these meters. So he's looking at, they're all the test meters that were provided to him by counsel, for Hanna in this case, to do the testing, to draw conclusions to apply to the real water meters. And of those 15 meters, he's getting different results from some of them. And so he's comparing those meters, and they're different. They have different probes. Then, if we can go back to page 9 of the motion, this is his testimony. I asked him, well, did you do anything to inquire into why the data from these 2 meters were inconsistent with the data from the other 13? And he says, well, when I spoke to Mr. Rasmussen about this, we looked at these 2 probes for the 2 meters that had data that were outliers, and based on the construction of the probes and the serial numbers that were on the probes, it was relayed to me that these probes were older and had been manufactured in a different location where they may have been affected by the exposure of colder temperatures during shipping that can affect the way they perform. So he concludes that, oh, well, I can just exclude these 2 meters from the testing and go with the 13 because these are different. They're older. They were manufactured in different places. They were manufactured at a different time. They might have been exposed to cold weather. So I'm not going to consider those. Those test results I'm not going to worry about those test results. I'm just going to worry about the test results with the 13. Okay, so that begged the next question when I asked him, well, okay, so you have 15 meters that you were provided to do your testing by Hanna and counsel, and there were differences in those meters that affected your test results. What did you do to determine or compare the actual meters that Real Water used to the meters that you were testing to see if those would have been different or how your results would even apply? And he said, well, I never did anything. I looked at pictures of them, but did not look at the probes, did not compare them to any of the meters, did not determine the serial numbers on any of them, did not determine when they were manufactured or where they were manufactured or how they were shipped, or do anything to determine whether those Real Water meters, the actual meters used by Real Water, which we had ready for him to look at, were comparable to the 13 test meters that he tested, the 2 outlier meters, which, those 2 were, there wasn't a detailed comparison, but one, the results were substantially lower than all the other meters. One, I think, was a little higher, but there could have been difference between those 2 that he didn't examine. But he didn't compare the Real Water meters to the 13, to either of the 2 outliers to determine if they're similar to the 13, similar to one or both of the outliers, or similar to none of them, or account for how any of those differences may have affected the test results as applied to the actual Real Water meters. So ultimately, he cannot say that the test results would apply to the actual meters at Real Water, used by Real Water. He can't say that the 13 results from the 13 test meters, let alone the results from the 2 outlier meters, would apply. All he can do is just say, well, I speculate these test results would apply to the actual meters that were used at Real Water, when in fact not even all his test results would apply to the real water meters. He had different test results because of differences in the meters that he cannot say were or were not present or similar to the meters at real water. To suggest that any of his test results apply to the real water meters actually used is pure speculation and unreliable, which is by itself required to be excluded under the Hallmark standard. But there's a second problem, main problem, with Dr. Babcock's testing. When he performed his testing, as I mentioned, he created a test solution. And the negative ORP of the test solution that he used was approximately, on average, negative 115 millivolts.
150?
115.
You said 150, okay.
The target negative ORP at real water was between negative 225 and negative 300 millivolts. So if you recall, what the issue here with the meter is, real water was using this meter to take negative ORP measurements and using those measurements to determine how much concentrate or hydrazine it was adding to the finished product water. And these meters, and if the meter was a little low to the target range, real water would add more concentrate to the water. These meters were not reliable for reading negative ORP meters because they needed to be oxidized before they could reliably or accurately read negative ORP. And there was no warnings, no accurate instructions on how to oxidize these probes before using them to take negative ORP measurements. So that's the crux of it. But so obviously, when we are talking about the accuracy of these ORP probes, which really Dr. Babcock never tested, but even if you're just looking at the stabilization time, the circumstances that existed was the stabilization time or accuracy to get to the negative 225 to negative 300 range, not the negative 115 range that Dr. Babcock performed his testing on. And so Dr. Babcock did a bunch of testing on a test solution of negative 115 millivolts, in that range. He has various results from his testing on solution with negative 115 millivolts on average. But he cannot say if the test results would be the same or different, and or how different, at the target negative ORP range at real water. It's pure speculation. All he's saying is, well, this is my result at negative 115. I guess it applies to that. I don't think it would be any different at negative 225 to 300, but he never did the testing. And there's no reason for him not to have done the testing. He could have. There's no reason why he can't make a negative test solution at the range of real water that existed at real water, but he didn't. He did all his testing on a solution at a negative ORP range that was less than half of the mean range that was the target at real water. And so any opinions from Dr. Babcock based on his testing that he did on completely different meters that he can't say are similar in any way to the meters actually used at real water, and any testing he did on a negative ORP solution at a range that was not anywhere near similar to the range used at real water, to allow this evidence to the jury to suggest or infer that Dr. Babcock's opinions or testing or results would apply in any way to the actual conditions that existed at real water is pure speculation. That's why the substantial similarity standard exists under Hallmark, and that's why the motion should be granted.
Thank you, sir.
Afternoon, Your Honor. Scott Rasmussen on behalf of Hanna Instruments. I didn't realize that Mr. Pepperman was a chemist. I did not know that. It's the first time that I've become aware that he's able to provide this court an opinion about pure speculation on testing by chemists. Because his expert, Michael Motley, is not a chemist, is not a scientist, and has not said that. Could we, first off, deal with these particularly, according to him, big problems? So I want to first go to.
And can you explain to me, for what purpose is this opinion being offered?
Good point. Foundation. His opinion is going to be that the MW 500 Milwaukee meter has this much time in order to, out of the box, and then at 5 minutes and 72 hours and 96, it takes this much time for it to do a reading, a measurement. You see, the theory is that if you don't condition this particular probe for 5 days, it can't read anything at all. That's not true. You can read both negative and positive right out of the box. And that's the only reason that it was done. Can you go, Mark, for me to.
And I just for the record, because I'm always asking these questions, because I
Sure.
don't know the answer to them.
Yeah.
Why didn't he test some of the meters that were available? Because it's my
Great question.
recollection, they had a lot of meters, right?
They had 2 that we found when we were there. So let me go over this. It's a real simple question, okay? We went and actually did do an inspection of the meters that were supposed to be in an evidence vault being held by the plaintiffs. It was ordered by Judge Gonzalez back well before this court had this particular case, okay? When we first asked, we thought, well, I'm sure they're keeping the meters at their office, because right on the warnings label it says temperatures will affect the failure rate of the meters. Instead, what we found during discovery is that the plaintiff's counsel was keeping the meters in a storage facility like all around town that you can go to. You drive up and you line up against the garage door, you open it up and there's a box of stuff in there. But it wasn't air conditioned.
Tell me this, and I'm just asking these questions.
You bet. I'll answer the next one.
As far as the plant itself, is the plant air conditioned or not?
No,
Okay.
not where they were at. Let me take that back. There are some offices that are in there. Then there's an area where they have the tanks and stuff like that. I asked this very question to KCA. He says, no, it was always hotter than a pistol in there. So does that affect this? Well, yeah. I mean, Mark, there's a photograph of the warning label. You don't have it yet for Maria? Or is it over with Chris still? So that Mark can use it. So this is the actual box. It's the same warning.
And do we know how old the meters were? I mean, I'm just trying to get.
You got it. How old the meters were?
That were being used by Will Water.
Several years old. And the expected life expectancy for a probe, 6 months warranty. That's it. So in other words, if we tested something that only has a lifespan of 6 months, what good does it do me? Better yet, if you leave that same meter and the probe in the Las Vegas temperatures inside of a storage facility off of Decatur, how much does that, and I'm not sure that the address is Decatur.
Craig Road.
What?
It
Craig Road.
Craig Road, I'm sorry, I
doesn't
apologize.
matter though, it's in a warehouse that's not air conditioned.
Right,
and
right.
Whether it's on Craig Road or in Henderson, it's
Right.
all the same.
So we showed the photographs of this to Dr. Babcock, because I can't test those. I says, why? And he goes, look at the solution that's covering the probe. I go, well, he goes, no, look, it's all crystallized on the outside. These probes are dry. And clearly in the instructions, it says must remain moist at all times. It says it right in the instructions. I have a motion for this court that's already gonna be teed up now that says you spoiled the evidence, plaintiff's counsel. I can't test these. And what you wanna do instead is come before the court and say, hey, you didn't test these meters that we have. And it's like, well, of course we didn't because they're spoiled. We have a declaration from Dr. Babcock in that motion for spoliation that says, I can't test these. Now, he's a chemist. I know Mr. Pepperman suggested today that he was one as well from the testimony he provided to court about all the different things that was pure speculation. But he's not a chemist either. He's an advocate and he can say what he wants to the court. But Dr. Babcock looked at those probes and those meters that have been kept for over 2 years by the plaintiffs and said, I can't test them. 2 reasons. 1, they're too old. Number 2, the temperature affects them. And why is that? If we look at this on your screen.
And here's my next question. I'm just trying to get foundational.
Got it.
Any idea how the meters were that were being utilized at real water?
Over 2 years old.
And so they were over 2 years old too. Okay.
Let me go to here just so I can show you what it says. I don't know what screen it's on for you.
No, I have it right here.
It says warning. Okay. The enclosed product is intended for use by persons knowledgeable in safe laboratory practices. Okay? Failure, then there's accuracy, okay? Can result from surface damage. We know there was surface damage done to these probes at the real water facility when they were using them. Casey Aiken said so. He took them, he put them into 5-gallon jugs and then used them by hand. It's just not the way you do these. It's not safe laboratory practices. Improper pressure or temperature. So if you store these things in improper temperatures, what the plaintiffs did with the meters that they had the real water thing, then it's going to affect them. And you can't use them with improper chemicals. Well, what chemicals do we have that we can't use under the ASTM standards that were followed by Dr. Babcock? Hydrazine. We've talked about it forever. We've talked about this whole case.
Explain that to me.
You bet. Let me get the definition of hydrazine for you.
No. As far as how we get the hydrazine, I mean, I understand what that is.
Okay, then I'm going to link it up in two sentences. One, I need to go to this first. It's foundation for what's going on. There's a definition right there. This is from Oxford Dictionary. Hydrazine is what? A colorless, stable gas with strong alkaline reaction. Also called diamide, I'm going to pronounce this incorrectly. I get screamed at every time I do. Yeah, thank you. I messed up. Then it gives right there the standard, or the its atomic numbers. And Mr. Neale said this in some of his testimony. It's N2, which is nitrogen atoms 2, hydrogen atoms 4. The problem with that is it's very unstable in that particular form. We've already discussed that, okay? Why? The reason that it's unstable is because it's always searching for other hydrogen atoms to bond with, okay? So with a strong alkaline reaction, let me explain what we're doing here. Nitrogen is next to oxygen on the periodic table. I don't think anyone's going to challenge me on that.
Periodic table.
Periodic table.
I'm just gonna say you challenged him.
Love it.
Anyway, I kind of get that. I understand
7.
Carbon
Right.
and hydrogen and.
Yep. Oxygen is 8.
Yes.
Nitrogen is 7.
Right, I get it.
It also means that's the number of protons in the middle of its nucleus, and that means that how many electrons are going around it. Electrons have a negative charge. In this case, if I have 2 of those, it means I have 14. Okay? I've got 4 more hydrogens, because they've only got 1 apiece to help bond with this thing, this hydrazine. So now I'm at what? 18. And what I need to do is get to these 16 numbers, and then after that I need to get to 24. It doesn't make sense. Now part of that is because nitrogen is going to take 2 of those electrons and take them out of service. I'm not a chemist on these things, and I'm not going to testify as an expert on it, but I just don't have enough hydrogen. So what happens is when this alkaline, as it says right there in the Oxford Dictionary, says strong alkaline reaction, means that when I put that into water, that particular chemical will try to find hydrogen. Well, where can it? Well, we all know what water is. It's H2, 2 hydrogen atoms, 1 oxygen. It's a pretty stable, water molecules are very stable. Okay, why? Because they actually fulfill the octave requirements, which is a whole different thing we don't need to get into, but that doesn't, N2H4 doesn't. So it's always trying to do this. So what happens, when it takes a hydrogen from water, a water molecule, it's transitioning it to an OH negative, because it's just stolen an H atom. Not getting into it too far, the answer to that is that now that I've got OH negative, that starts your alkaline process, which means alkaline water is negatively charged. Alkaline water is negatively charged. Real water was trying to make alkaline water, or negatively charged water. That's what they were trying to accomplish. That's what their advertising was. Okay? Let's go next to the big problems. Mr. Pepperman suggested there's a big difference between a white casing on a MW500 probe and a black one. I guess he doesn't like the color black. I don't know why. This is right here at the bottom, it says MW500 probe ORP meter. Right there, MW500. If you go to the plaintiff's motion. Yeah, 28. It's run MIL 28, right?
28, yeah.
All right, he's got a picture of this.
So I have it right here on page 8, I'm looking at it.
Right. So what happened at Hanna is they said, we'd like to change the color of the meter casing. Okay? All right. We'd like to go from a dark blue coloring on the right side with white to green and black on the other. That's what happened. I think they also changed the size of the LCD board as well a little bit, but that's the meter. That's what they did. They changed the color.
What about the probes?
Didn't change those at all except for, again, the color. Okay? We also know that all of the meters, because of the time period in which they were sent, were all sent from a country called Mauritius. That's where they were manufactured and sent to real water.
What's the country again?
Mauritius. It's an island in the Indian Ocean off the coast of Madagascar. It's a Hindu country with, that's what I just said, probes. I'm sorry, if I said meters, I apologize to the court, that would be incorrect. The probes were made in Mauritius. All of them. The two outliers that he wants to talk about were not made in Mauritius. They were older.
So the two outliers weren't made in Mauritius.
Right.
Do we know if the gray was made in Mauritius or not?
Yes. All of them in Mauritius. Now we get to this other convenient one is that, we'll get back to it, but there's two terms. He says that there's two different meters. One's black and one's white. Somehow black is bad, but white is good. And therefore there's two different kinds of meters because one is colored black and one is colored white. Now, let's go to their particular, page 10 of this document, please, Mark. This is probably the most important part of why this is ridiculous on this part.
Is this page 10 of the opposition?
Yeah, no, their motion.
Okay.
Let's go down to line 21, and we'll start there. This is the deposition testimony of Dr. Babcock. The 15 Milwaukee test meters that were shipped to you by Hanna's counsel for testing, those 15 test meters look different than the real water meter, correct? Babcock's response, yeah, they're certainly a different color than this meter. I believe there was some testimony about how they repackaged the outside of the meters. In other words, the casing, with a different color scheme and graphics, which I talked about the LCD board. Did you do anything to compare this type of meter or any of the other meters at the real water facility with the meters that you use for testing? Well, first, we can't test the meters. We have a motion up for spoliation because Dr. Babcock says, once I saw the photos of this thing, there's no sense in testing them. They're spoiled. I can't do it. And he has a declaration. Now, there's no scientist in the response in their opposition to the spoliation that says, oh no, you can still test those. Mr. Pepperman says you can still do it, because I guess Mr. Pepperman is now a chemist that can say you can do anything, even though a chemist says you can't.
Here's my next question on that.
Right.
Was there an attempt to test them to see if they function, the meters?
No, because Dr. Babcock says there's no reason to do it as a chemist because I saw the photographs of them, I saw that they had already dried up, therefore they were spoiled.
And when he says dried up, are you talking about the probes?
Yes. So let me go over that so you can see this. Here is the probe. Okay? If you'll look in there, there's a green substance covering this. I'm not going to take it off. I don't want to do that in your courtroom. Okay? That's a gel that encompasses this. When we see the photographs and they're attached to the spoliation motion, this is gone. This green stuff is out of there. Why? It's left and it's crystallized on the outside of this, which means it's no longer moist. And if you don't keep that probe moist, it won't function. Not my fault. I don't have control over the meter. So why would we test something that can't do it, we can't test? Let me go to the last question though. Could we go to page 11?
I'm on 11.
Okay, let's go to the next one.
Is that page 12 or not 10?
All right, so, yeah. I'm sorry, we need to go back up one more. All right, let's start right there. Did you do anything to compare this type of meter or any of the meters at the real water facility? Well, all I've seen are photos, which I just told you that's what he did. He looked at those photos and saw the crystallization on the outside of the probe. So I haven't looked at it in person to try to see if there are any differences, but no, the meters that I tested were obviously of the new style of casing. So a style change was made. Not a new meter, new style. And you know, next one, Mark, next page. Nope, up, next, yep, thank you, Mark. And you know, the difference from this than the appearance of the meter, it's no different. Then he says, but it's my understanding from testimony the packaging or outer casing material was changed. Here's the important part, here's the line. But the function of the meter didn't change at all. In other words, what this 500 MW500 meter does, and what the white meter does, the function of the two, in other words, testing solutions for millivolts, that function didn't change. Black or white, they both can test millivolts of electricity in solutions. The function of the meter didn't change at all. Now, Mr. Pepperman just told you the big problem is the meters were different. And I'm telling you what the big problem is, because in their own motion, it says, this is the stuff they told you. But they didn't read this part, that the only style difference was one was black and one was white. But the function of the meters, be it white or black, didn't change. Then the white meters that they do have, they take over to their shop, they put them into a storage facility in the Las Vegas heat, and it doesn't have to get that hot, 125 is sufficient, and these things break down. Not only that, these probes, that's the meter. The probes have to stay somewhere where this stuff doesn't dry out. Or you can't test them. You can't look at them because, I mean, you can look at them, but you can't test them to see if they're still available to test anything. And the useful life of a probe is only 6 months on warranty. Which means after that, we can't guarantee that anything works appropriately. Okay?
Well, can't we agree useful life is slightly different than warranty, right?
I agree with you.
Okay.
I agree with you. But remember, we also have 3 other things you can't do to these things. Surface damages, temperatures, and
No, I
chemicals.
get that, but coming back again, I'm trying to, for what purpose would this testing be offered?
Fair enough. And
the
I'll
reason
say it
why-
again.
And the reason why I ask that, because just understanding what the claims for relief are concerned regarding whether this product is effective or not, it appears to me they're focusing on box and or product insert warnings and those types of things.
Can you show the tip card mark? Do you know what I'm talking about?
Isn't that the case as far as they're concerned?
Yeah, so it's pretty simple. No. Let's go to another photograph. We'll get back to that one.
Because here's my next question.
Yeah.
Is there any allegation that notwithstanding the
There it is.
warning issues and the like,
Yeah.
right, that the meter in and of itself was defective?
They claim that if you don't oxidize the probe, that the meter will not read accurately.
Okay. But I understand that, but I mean, that's
Yeah.
a slightly different issue, but I mean, you know where I'm going. I mean,
Go ahead,
Yeah.
go there, so it's on the
yeah,
right.
and so my point is this, they're alleging that, and I don't have their complete theory in front of me, but I know it's based upon product warnings. right?
Yeah,
The
yeah.
lack thereof.
Oh, no, they have 2 causes. One is that this is dangerous. This is dangerous. This right here, the 9 volt, this is dangerous to consumers. I don't know where that comes from, but I'm not sure exactly. I guess if I threw it at someone's head, that would be dangerous, but I don't know why that's dangerous. The dangerous part for them is, well, if it reads inaccurately, then people like Joel's client you could use it and have a bad result. The problem is that there's no really good testimony at all from someone competent who actually is a chemist, because there were no chemists that were ever hired by Real Water to tell us whether or not it was inaccurate or not. There's no foundation to say it was inaccurate, ever. I can't tell Real Water who to hire to do things, but Blaine Jones, not a chemist. John Marlowe, not a chemist. Casey Akins, the guy who's actually using the probe, not a chemist. Anthony Brown, the supervisor, not a chemist. Diego Mendigana, not a chemist.
And I know I saw this somewhere, this is on page 6 of the motion. Quote, plaintiff claims that the MW500 was defective because the meter gave persistently inaccurate negative meter readings because it required a confusing and cumbersome oxidation process for negative ORP readings, and because the MW500 was not accompanied by a suitable or adequate warning or instructions concerning these risks and issues.
Right. So let me help. Unless one, you need.
No. And so, and they kind of flip back to questions of for what purpose
Yes.
we were here.
Okay. So let's make
And
sure.
I guess for what purpose the testing was conducted.
So the testing was conducted to show that right out of the box, not oxidizing for 5 days, 4 days, 3 days, 2 days, 1 day, 5 minutes. All 15 of those ORP meters read alkaline water at negative 115, according to Mr. Pepperman's 115. Okay? So in other words, what they're saying there is it was confusing as to how long to oxidize them. And what he did the testing for was to show that right out of the box, all 15 of these meters read negative. Now, the 2 outliers were within 5% of the other ones. statistically not important to Dr. Babcock, and he will testify to that. Okay? Just as important, negative 115 to negative 225 on a meter that has a 2000 range, the difference is 5%. Again, is that substantially different? 5%? No. Now here's the other thing that we couldn't do. This is important.
Okay, I'm listening, and I got a question for you.
You want to do the question first, or you want me to go to this?
No, you go, where everything's important, I want to hear.
Okay. What could we not do that Real Water was doing in order to test? We've talked a lot down here, Your Honor, about something that Real Water did that was unique and unintended. Real Water took 2 Russian-made titanium tubes coated in porcelain and used those to make their water. Those 2 porcelain, Russian-made, that's the words that we're supposed to use, Russian-made, porcelain-coated titanium tubes, okay, were not available to Dr. Babcock in order to do any of the testing similar to what Real Water was doing. We can't go to a market and get Russian-made products in 2023. There is an embargo with the country of Russia, so that we can't buy those and bring them in and use them as part of the testing stuff. Why? Because this is not my policy, but we can't get them.
No, I understand that, but why is that important?
Okay, so let's go over what those titanium tubes did. What you've already heard and what we talked about is that when you negatively charge this water, that in that process, hydrazine was made. Why? Well, the nitrogen for the first time is finally introduced with the porcelain. The porcelain coating has nitrogen atoms in it. Okay? So now I've got nitrogen. Now that I add the electricity and I put it into an area with low hydrogen anyways. Okay? And those nitrogens subject to the electricity is likely to make hydrazine. Okay? So now, what can't I do? Well, Mr. Pepperman says I need to make this just like Real Water did. I don't have access to those tubes to put hydrazine into the solution that's there. Not at the amounts that are there in the concentrate that was looked at. Remember, the highest amount was 300 parts per billion, okay? Remember, we're not testing it to see whether or not hydrazine will take you to an alkaline level that's negative 225. We're testing to see whether or not it gets negative at all, because the plaintiff claims you can't get a negative reading unless this is oxidized. That's not true. Let me say that again, Your Honor, so I got it on the record. The plaintiffs claim if I don't oxidize that probe, I can't get a negative reading.
Here's my next question. How did the oxidation process occur in Real Water?
How the oxidation process did. So they had 2 different things that they did. And at least 2 different people have testified, if not 3 different people have testified, 4 actually have testified. What they did is they would take that cap, you've seen that on the probe now. Okay, after they have oxidized it with distilled vinegar, I've got a photo. Can you show me that photo of the distilled vinegar? This one right here, Mark.
It's on the screen.
Thank you. They used distilled vinegar. Casey Akins testified. What did you store the probe in after you used it? Answer, distilled vinegar. Mendigana testified. What did you store it in? Distilled vinegar. What did Anthony Brown say? Distilled vinegar. Blaine Jones, distilled vinegar. What does distilled vinegar have to do with this? Well, it said it right there in that tip card. That's what we used to store it in. Okay? Did that answer the question?
Yeah, well, I understand that, but I'm trying to figure out the process they were utilizing in order to manufacture concentrate vis-a-vis Real Water. And the reason why I bring it up, because I don't know what the whole process was,
Yeah,
and I understand it involved potentially water and your client's meter, but also, what role did the ceramic titanium tubes play in the manufacturing process?
good point. Let me answer that question for you. So what happens is that those tubes have been electrically charged. They actually have a wire from outside of the concentrate maker that brings electricity to those tubes, okay? The water is then charged. As the water runs through the tubes, it's going to get charged, positive and negative.
Okay, and so when that's going on, at what point do you start utilizing the meter?
Not then.
Not then, okay.
Okay, so it goes through and they separate the positively charged water through the use of these tubes from the negatively charged water. They preserve that, look, I don't agree with the science on this, but
I know, I'm just trying to figure out what's going
look,
on.
this is the part where I'm a little bit lost by how they do their charging of water to make it so that there's only negatively charged water in the tanks of the concentrate, but they claim that it's all negatively charged water, okay? And the positively ionized water is flushed down the drain. It's Blaine Jones' testimony, okay? The negatively charged water is then preserved, okay? And at this stage is when he adds new chemicals. Those chemicals that he says he adds, and let me say he, let me make sure I have authored that. There are two different authors. One is John Marlowe. It's his design. It's his design to use these titanium tubes. It's his design to use the following chemicals. Now, you just need to understand. Our companies, Hanna, Milwaukee, we have no idea that titanium tubes manufactured in Russia are being used anywhere in making of water.
And
We don't know.
I'll be a little clearer, ceramic titanium.
Sorry, it's coated, yes, we have no idea.
I'm learning as we go on, but here's my next question,
Sure.
and I have no clue on this. I mean, I really enjoyed it. These are just questions I have because I'm learning a little bit more about the case. When it comes to the manufacturing process, what impact does the ceramic titanium tubes have on the solution?
Okay, so you have negatively ionized water. That according to John Marlowe, this is the best way to make it as negatively charged as possible.
Okay.
Okay? So now it's just negatively charged water.
So it's going one way and the positively charged water is going somewhere else, that's
Yep.
going down the drain.
And then they reverse this and do it again, get rid of the positive and negative. So they're trying to make it as pure negative as possible.
And see, here's my question.
I don't know why they're ceramically coated, by the way.
I don't either, I have no clue. But my next question is this. When the testing occurred in this case, were the conditions the same conditions that occurred where you had the ceramic titanium tubing?
Right.
You have the processes, whatever they might be, in place. You bring the water in, and then you have the positive goes one way, and the negative's going another way. And then I guess maybe that's when they charge or test the negative. Is that what they did?
Is that what real water does, or is that what my?
No, that's, no, I'll make it real clear.
Sorry.
That's how Real Water was utilizing your clients.
Not even here yet. Not even yet.
Not even, oh, wow.
Not yet. No, but this gets even further into the
Weeds.
weeds.
Yes.
Okay.
Okay.
So at the stage that we've divided, positive from negative, loop it again, positive, negative, okay? And we're at 3:53, we got 7 minutes until this gets over, so maybe what Ms. Tori is trying to tell us is I need to wrap up.
No, you don't need to wrap up because I'm not gonna.
I don't think we should finish this one today.
I don't think so.
understand, that's what I'm saying. We can maybe
continue to
conclude
Monday.
there, but no, I wanna listen to this whole, you're educating them on the process. as
Okay,
much
let me finish up with some process then.
Yeah,
And then we can leave it, and I agree with Mr. Kemp, that this can't be finished up today. And so we'll work for it on Monday, okay?
that's fine.
At that point where I've separated according to how Real Water thinks it's done. This is not my mix. I'm not counseling within, this is how you should do things.
I understand, you're just, your product is just on the market. I get
All we do is, here's a meter that'll tell you if it's negative or positive, that's all it does, okay? And it doesn't say up or down, doesn't say there's hydrazine, all those things, okay? At that point, Mr. Marlowe introduces into this mix three different chemicals in the amounts, exactly we don't know, but here's what they are. Potassium hydrochloride, potassium chloride, and magnesium chloride. Did I mess up on those?
You messed up on where they're introduced, but you got the name.
But they're in the concentrate.
Before they put it through the titanium tubes they put them in. Because they have to, you
Right.
can't have purified water, you won't hold the electric.
But it's all in the concentrate.
It's all in concentrate.
All right. So these chemicals are put into the mix. Okay?
Okay,
Before or after? I thought it was after, but you're saying it's before.
It's before because, think about it, when you do
Yeah.
an electrical charge,
Yeah.
you purify water, you can't hold electricity.
It's
So
true.
You have to put the chemicals in there because they are what holds electricity.
All right. I'll agree with Mr. Kemp on that. And so these chemicals, I don't want to use that word, these are minerals. To be honest, they're salts.
okay, I understand. Which
Okay?
kind of makes sense because they can have corrosive effects and maybe, I don't know. On the
But more than anything, they also steal hydrogen.
Okay,
So they're alkaline in the way they behave as well. All right, so I've got an alkaline base, and then in the titanium tube area, we've added now just negatively charged water, and in that process now, hydrazine is created, we believe. Why do we believe it's there? Because we find hydrazine in the concentrate. Okay? Okay. Then, at that point, the concentrate is put into containers, 2.5 gallon containers, 5 gallon containers, 5 gallon containers.
okay. But here's my next question. So when are the probes used?
That's not even yet.
Okay,
This is why, this is how far away that 5 gallon containers are made, okay? Those 5 gallon containers are taken to 2 different tanks of purified, filtered water, probably a better word for it.
Purified.
and so I guess, and at that point, are the 5 gallon containers the concentrate?
So there's a 5 gallon container
This is the concentrate.
and an 800 gallon container taller than me.
Yeah, I've seen those in the photographs.
Right. And a 500 or 651, I think, something around that range, was a little smaller than the 800, okay? Into those is dumped the 5 gallon concentrate, okay?
Okay,
At that point, okay, it starts what they use what is called a recirculating pump. Now, we will have Dr. Babcock talk to you about what is a recirculating pump and whether or not it has the strength to even circulate a mixture like this with just one pump. And just understand the Henderson plant, for the first time that we can tell, they go from 2 pumps to 1 pump. Okay? Then the water is supposedly mixed for, I think, 24 hours. At that point, it then goes to the D&L machine. So Dewey, what's it, Jim?
Dostal and Lowy.
Dussel and Lowy, okay? This is where it's a combination, we're gonna wash the 5 gallon jugs, we're then gonna fill the 5 gallon jugs. And then we're gonna supposedly, in all of this piping that goes on, we'll make sure that we've done a UV test. We're supposedly supposed to clean the bottles, not sure that was going on. And then Casey Akins takes them out of this machine, puts them on the ground, takes his hand in a rubber mallet and a cap, and he's about ready to seal them, and he puts a probe into the 5 gallon tank from Milwaukee and gets a reading. Okay?
what's the chemical composition of the water at that point?
We don't know because there's nobody at Real Water that's testing the chemical composition of the water.
And here's my final question, I guess we can break the leaking. At that point when the probe is being inserted, and they insert it into each 5 gallon?
No, one, and then they dump it.
One.
One out of, so divide 5 into 800 is what? 160 different 5 gallon jugs? If I did my math right?
And as far as the jugs are concerned, I want to make sure I'm clear on this last point. Are these the jugs that would have been shipped out for?
Home delivery.
Home delivery, okay.
That they're reusable plastic containers like you see on a water cooler.
It's
Okay?
the same process with the retail bottles too, Your Honor. They all make the same concentrate made by Blaine Jones with the titanium tube, and it's shipped around, and then that's used to make the finished product water, and then in the same recipe, and it's just whether it goes into a 5 gallon bottle or a retail bottle.
And I just want to make sure the probe is not inserted into the concentrate, it's inserted into the.
To a test bottle, Your Honor.
To a test
There you
bottle.
go. And then how long is it inserted into the test bottle?
As long as it takes for it to stabilize and give you a reading.
Okay.
And according to Dr. Babcock, it's a couple of minutes. Even right out of the box. But it gets faster as it oxidizes, as the white vinegar is, it's storage in.
So
But
that's
right out of the box, it'll do it, 2 minutes.
But that's part of the curing process, I guess?
Conditioning?
Conditioning?
Right. Now, the problem is that, well, let's not get into it, it's 401, but Michael Motley, their expert, says that the problem is calibration. And I need to make sure that the court understands that calibration is not an issue in this case, and that Mr. Motley's opinions as a non-chemist can be used with regard to calibration. It could be that Mr. Motley is just mistaken with which words to use. And I'll let the
And
plaintiffs-
Mr. Motley is who?
plaintiff's social scientist. I'm sorry, I've gone to 401.
That's okay, sir.
I'm gonna stay up here, I've got some more things to
Oh,
go
yeah,
through.
we'll start first thing with you Monday, what time? 9:30.
9:30, Your Honor?
Yes.
All rise.
Okay.
You want to